welcome to Prime Property, your weekly real estate reckoner. I'm Nayantara Rai and this is what we have on the show today. In a body blow for DLF, it's been directed to pay 630 crore rupees as penalty for abusing its dominant position in Gurgaon, as its 3-year-old appeal has been dismissed by the Competition Tribunal. The realty major says it will appeal at the Supreme Court, while the Victoria's Bar Association is getting ready to file India's first class action suit against DLF. This landmark verdict has given new hope to aggrieved buyers across the country. We reach out to the Victoria's DLF Buyer Association on tips to seek legal umbrage. In Maharashtra, the proposed act to empower home buyers is expected to miss its June 30th deadline. The move to set up the country's first housing regulator will now also be delayed. It's a body blow for DLF. The company has lost the second legal round against its consumers in Gurgaon and has been directed to pay 630 crore rupees as penalty for abusing its dominant position in the city's luxury housing market. This as the Competition Tribunal COMPAT upheld a 2011 order of the Competition Commission of India and dismissed DLF's 3-year-old appeal. Legal eagle Harish Salve is used to winning, but this time round he's on the losing side with DLF. The company has already said it will move to Supreme Court. But just to put all of this in perspective, this 630 crore rupee penalty is a tad lower than the 660 crore rupee profit declared by the company in FY13 and higher than the 550 to 600 crore rupees being predicted by analysts for FY14. Moreover, the company's debt stands at over 20,000 crore rupees. At its end, though, the markets shrugged off the verdict, with the DLF stock zooming over 25% this week. These were the members of the Buyer Association that spearheaded the fight and have literally brought DLF to its knees. The association members say they will now seek damages from DLF. Within 2 hours of COMPAT dismissing DLF's appeal, the Buyer Association sent out an email to hundreds of its member buyers saying, and I quote, "We will now seek compensation from DLF separately. There is no question of any settlement with the realty major. We will now file a class action suit against the company as per the new Companies Act. If this actually happens, it would be India's first class action suit under the new Act," unquote.
The compensation comes to us through a section called 53 in the Competition Appellate Tribunal, in the COMPAT scheme of things. So we will have to apply for that.
At the epicenter of this fight are 3 residential projects of DLF in Gurgaon: the Bel Air, Park Place and Magnolia on the company's golf course. COMPAT found DLF abusive in its practices of modifying super area, common area and increasing the height of buildings midway through the projects. The buyer's main grievance has been the delay in project delivery, as DLF increased the number of stories midway. For instance, from 998 to 1,500 apartments in Park Place alone. DLF on its part says it has respected in true letter and spirit the customer commitments made by it. In testament thereof, out of over 2,600 total number of apartments, over 2,200 have been handed over and over 1,800 families are already residing therein, unquote. But is the decision by the COMPAT a watershed moment for home buyers?
An average builder would be extremely careful now, and he will be perhaps consulting and rushing to competition law practitioners to show and tell them that whether he can be held to be dominant, and if he is dominant, he'll be extra careful. So this awareness from both sides, to the builder to be careful, as well as the consumers and customers, that they cannot and need not take things lying down.
The COMPAT, in its 150-page judgment, says DLF increased the height of the 3 projects and started construction of the additional stories in absence of government sanctions. While the COMPAT ruling stops short of saying DLF colluded with the Haryana government's state officials, it has certainly hinted at it in several instances. For example, COMPAT said, and I quote, "It cannot even be imagined the district town country planning of Haryana, or as the case may be, the civic authorities were not knowing about the additional construction, which were going on in full swing without the necessary approvals and without the sanctions of the plans," unquote. But it's not all bad news for DLF. In a major relief for the company, the COMPAT has disagreed with the 2011 ruling of the CCI and said DLF does not have to modify its buyer agreements. COMPAT said the Competition Act as it stands today came into force in May of 2009 and cannot be retrospectively used to change agreements DLF had signed with buyers in 2006 and 2007. But the COMPAT has left a window open for consumers to demand a modification of all those agreements signed post-May of 2009.
In case of DLF, there have a number of cases which have come up, but a number of cases have been closed as well. But a good number of cases, it has been held to be dominant, and on the basis of the dominant position, already investigation is going on before the Director General. So when they come now, one thing is certain, that about the dominance is proved and upheld by Competition Appellate Tribunal, some of the abuses. So those cases will not become simpler now, and only template orders required to be passed practically after giving the effect. So that is going to affect many of the projects of DLF.
With the COMPAT in this DLF case upholding the consumer is indeed the king, many aggrieved buyers are hoping to take this route as umbrage against their builder. I caught up with the counsel for the DLF Magnolia Buyer Association to find out more about consumer rights. I began by asking him how buyers of a project must start by setting up a legal association or society.
You see, the association needs to be formed under the Societies Act. There is a Societies Act in place. For example, in Haryana, there is now a special Societies Act only which covers associations per se all over, whether it's an association of apartment owners or whether it's a society otherwise formed for some fine arts or culture or anything. So you have to apply, make your bylaws. There is a minimum number of people who are required for formation of these societies. 7 in some cases. If the society is large, you have to have collegiums, and then you can divide the societies of 350 members each. But that is only in Haryana. In other states also, societies can be formed under the Societies Act. There is a whole procedure which has to be gone through, and more important is you should have a bylaw.
Mr. Khanna, many consumers are looking at the DLF case with a new lease of hope that, one day they will also get justice against the builder. Tell us, what convinced you to move the CCI? It's the first such case against the competition watchdog. DLF has been reiterating that this is beyond the CCI's jurisdiction, that the CCI is not the right forum.
The size of DLF is so huge and it was so dominant in Gurgaon that it did not get affected by the pricing of the other developers or the other competition that was in the market. It could do whatever it wanted on its own. Now, if you are a dominant, if you are working with a dominant developer, then you may have a reason to go under the Competition Act to the Competition Commission of India. But in cases where you are not such a big company or where the builder is a small builder, the only remedy per se that an allottee or a customer would have is to approach the National Commission or the State Consumer Forum or the District Consumer Forum, depending on the fiduciary value of this whole claim they may have against the builder.
And for all those viewers that are planning legal action against their builders, can you enlighten them with the kind of challenges you and the other 2 DLF buyer associations had to overcome?
In any litigation of this type, and being led by owners or allottees whose apartments have been cancelled, the foremost thing is that they need to stay motivated throughout. It's an exercise of collection of huge statistical data which may not be easily available. This was one of the big challenges. The information that had to be brought in to really make your pleadings in this case was huge, and the gentlemen involved in our case were very, very motivated till the end. They knew that according to them, a wrong had been done, and they wanted to fight that. Now, this really doesn't happen in all the cases. And in most of the cases, you would realize that the developer or the builder takes advantage of that. Because at the end, only 2 people are standing fighting this whole institution. To stay together is very important, very, very important. Otherwise, it's very difficult.
And how do you react to the COMPAT disagreeing with the CCI and ruling there's no need for DLF to change the buyer agreements, that the Competition Act as it stands today came into force on 20th of May 2009 and therefore cannot be implemented retrospectively for all the agreements that DLF has signed in 2006? Do you and your clients see this part of the verdict as a loss?
By and large, yes. By and large, yes, it is a loss. For if I were to give my own opinion, I would only say that this was an occasion now to put in place a very simple template by a legal authority to say that these particular clauses need to be inside, modified in different situations and transactions, but the abusive clauses, as for example the interest which I have to pay and which the developer will pay, or the holding charges or many other charges, or the right of cancellation in every clause should not be there. You see, I can, in such clauses, a consumer can really not lift his head against the developer or say, listen, you are wrong. Because the only remedy that was left in these clauses was that you exit, take the money from us. The developer would say, we are ready to pay you. If that is the way you want, you have to leave, or we will give you 9% interest.
The COMPAT, like the CCI, has stopped short of saying there is a nexus between DLF and bureaucrats. It has, though, hinted at it at several instances of the verdict. Are you and your clients now considering a criminal case?
We have still to decide, and that is not for me to answer. These people will really have to go that far in that fight if they want to. But there are enough indications in this order which show that the states knew what was happening, and the state let it happen. And it was after the extra floors had already been built that the sanctions came in. So DLF was so dominant enough to start, keep on building these extra 10 floors without the state's interference. That was one of the arguments which was from our side. But what COMPAT said is that we are not going to go into the jurisdiction of the state.
Isn't it time now, Mr. Khanna, that there's some law that bans builders from increasing floors, from increasing FARs once third-party rights have been created?
Yes, that law is already there. You see, that is why I wanted to, although the judgment in DLF has not touched upon the Apartments Act, the Apartments Act itself gives a lot of right to the allottees. And there are not one judgments, there are many judgments of various high courts which say that you cannot just have the right to keep on building or change the land area or add 10 floors and this thing. But let me just touch the point of the Apartments Act, which is applicable in many states. That itself creates a lot many rights right from the day I become a consumer or a customer of the builder. And once the builder has declared a certain condominium area and said that I am going to make 500 flats there, and I start paying against one of the flats in there, the common areas are fixed, the facilities there are announced, everything is announced, there is obviously a service being provided to me to make all that and deliver to me, and my rights and interests are there from day one. So if the builder thereafter is going to change all that, it is going to be to my detriment. My rights will get affected. And that is not allowed. And there are many judgments of the High Court which I know of where these were challenged, and the courts have said that you can't keep on changing areas or the facilities and keep adding. It's not a fair thing to do. It would rather be illegal.
This is a very important point you're making. Most buyers don't know about it, that there are indeed laws banning builders from increasing the size of a project after it's been launched.
Let me take an example that a particular condominium is marketed by a builder, and he says, I'm going to build this in, let's say, 10 acres. And after everything is built, he says, no, I'm going to do it in 9 acres now. Or in those 10 acres, now I will put another 50% more flats. So my rights when are they going to get crystallized? Because I do not know. When is he going to make the changes? So therefore, there are judgments which you say that you cannot change my crystallized rights like this. And my rights do get crystallized the day I go to him to buy a flat and start paying.
Tips there on options available for you to take action against a builder. On that note, we're going to slip into a short break. On the other side, we'll tell you how the empowerment of consumer rights in Maharashtra has been delayed.